Buenos días y bienvenidos a la 20ª versión de nuestro seminario Día de la Competencia, el cual es organizado por la Fiscalía Nacional Económica. En esta ocasión lo hemos titulado Libre, Competencia y Mercado del Trabajo, y este contará con la participación de la experta Nancy Rose. Atendido que nuestra expositora no habla español, a continuación la presentaremos en inglés. Good morning and welcome to the 20th version of our Competition Day seminar, Competition and Labor Markets. Our speaker today is Nancy Rose, and Nancy is the Charles P. Kindleberger Professor of Applied Economics at the MIT Department of Economics and a visiting scholar in the Mossavar Ramani Center for Business and Government at the Harvard Kennedy School. Her research and teaching focus on industrial organization, competition policy, and the economics of regulation. Nancy was head of the MIT Department of Economics between the years 2017 and 2020. She served as the Deputy Attorney General for Economic Analysis in the Antitrust Division at the U.S. Department of Justice over 2014 to 2016. Saludamos y agradecemos a las autoridades que nos acompañan hoy, a las autoridades del Ministerio de Economía y autoridades del Tribunal de la Libre Competencia, a nuestra expositora extranjera y también a todas las autoridades y directores de las agencias de competencia de Latinoamérica presentes, así como por supuesto a todos los asistentes. Para comenzar, dejo con ustedes al Fiscal Nacional Económico, el señor Jorge Grunberg.
Muy buenos días, bienvenidas y bienvenidos a la 20ª versión del Día de la Competencia. Este es el primer día de la competencia en que me corresponde intervenir como Fiscal Nacional Económico. Se trata de un evento importante y querido para la Fiscalía Nacional Económica. A través de él, durante 2 décadas, hemos podido cumplir uno de los roles que forman parte del corazón de nuestra misión institucional: promover la libre competencia en los mercados. También es un evento relevante para quienes integran la comunidad de libre competencia: abogados, economistas, académicos y quienes forman parte de instituciones públicas y empresas, puesto que en él es tradición que se discutan temas de alto interés para nuestra institucionalidad de libre competencia, contando frecuentemente con expositores de primer orden a nivel mundial. En esta oportunidad, el tema que nos convoca es libre competencia y mercado del trabajo. En tiempos en que en Chile debatimos arduamente acerca de la necesidad de que en nuestros mercados exista mayor productividad y que nuestra economía exhiba tasas de crecimiento más altas, la promoción y defensa de la libre competencia en todos los mercados, incluyendo, por cierto, a los laborales, es una condición necesaria para poder alcanzar esos objetivos. Al igual que en los mercados de productos y servicios, en que la libre competencia entre los vendedores beneficia a los consumidores, quienes pueden acceder a bienes y servicios a menores precios, de mayor calidad y variedad y más innovadores, la libre competencia entre empresas empleadoras favorece a trabajadores actuales y potenciales para obtener salarios competitivos, mejores condiciones laborales y a su vez fomenta la meritocracia y la movilidad social. Cuando los mercados laborales son más competitivos, los consumidores también ganan, porque una fuerza laboral más competitiva es capaz de crear mejores productos y servicios. Los mercados laborales presentan características que pueden exacerbar los efectos sobre la competencia de las conductas llevadas a cabo por las empresas empleadoras. Los mercados laborales usualmente exhiben altos costos de cambio y fricciones asociadas al proceso de búsqueda, solicitud de entrevista y aclimatación referente a un puesto de trabajo determinado. Los costos de cambio también pueden surgir de inversiones específicas para un tipo de trabajo o una ubicación geográfica particular. Además, las necesidades individuales de los trabajadores pueden limitar el alcance geográfico y laboral de los empleos que son sustitutos desde un punto de vista competitivo. Por otro lado, para encontrar un empleo es necesario que el trabajador este proceso a menudo Reduce la gama de empresas rivales que compiten por un trabajador determinado. A la luz de las características que exhiben los mercados laborales, podrían darse situaciones específicas de mercados relativamente estrechos en que se requiera especial atención por parte de nuestra institucionalidad, porque es precisamente en estos mercados donde pueden presentarse situaciones reñidas con la libre competencia. Bien sabemos que la aplicación de las leyes de libre competencia en los mercados laborales es uno de los tópicos de mayor actualidad en el derecho comparado. En Chile, la institucionalidad de libre competencia cuenta con plena competencia para conocer acerca de conductas que impidan, restrinjan o entorpezcan la libre competencia en los mercados laborales o que tiendan a producir dichos efectos. En la jurisprudencia del Honorable Tribunal de Defensa de la Libre Competencia y de la excelentísima Corte Suprema existe claridad de que las sanciones a la obtención ilegítima y al ejercicio abusivo de poder de mercado contempladas en nuestra ley de libre competencia no solo aplican al denominado poder monopólico o poder con que cuenten vendedores en un mercado, sino que también al denominado poder monopsónico o poder con que cuenten compradores en un mercado. Es precisamente ese poder de compra, esto es el poder de mercado con que pueden contar las empresas empleadoras de cara a los trabajadores de manera de fijar los salarios y otras condiciones laborales por debajo de sus términos competitivos, lo que representa una legítima preocupación para la Fiscalía Nacional Económica en la medida que ese poder de mercado se obtenga en forma ilegítima o se ejerza abusivamente. Esto, naturalmente, sin perjuicio de que en los mercados laborales puedan existir conductas que sean intrínsecamente anticompetitivas, sin importar si quienes las ejecutan o celebran cuentan con poder de mercado, como es el caso de las colusiones duras. En el espectro de las eventuales conductas anticompetitivas en los mercados laborales que preocupan a esta Fiscalía, quisiéramos hacer referencia a algunas de ellas. En primer lugar, en materia de colusión. Las empresas empleadoras, sin importar si ofrecen los mismos bienes o servicios, pueden alcanzar acuerdos o prácticas concertadas que eliminen la libre competencia en los mercados laborales. Por ejemplo, a través de, por una parte, acuerdos o prácticas concertadas para fijar salarios, conocidos en el derecho comparado como wage fixing agreements, que no son otra cosa que acuerdos o prácticas concertadas de fijación de precios de compra del trabajo y forman parte de aquellas conductas colusorias descritas en los artículos 3º letra A y 62 del Decreto Ley 211 de 1973. Por otra parte, acuerdos o prácticas concertadas para no contratar trabajadores de una empresa competidora, conocidos en el derecho comparado como no poaching agreements, que no son otra cosa que acuerdos o prácticas concertadas de reparto de mercados, que consisten en asignarse zonas o cuotas de mercado, equivalentes al caso en que empresas vendedoras en mercados de productos o servicios acuerdan no disputarse a sus clientes. Este tipo de acuerdos o prácticas concertadas limitan la capacidad de los trabajadores de cambiarse de empleador y consecuencialmente de negociar salarios más altos. Estos comportamientos también forman parte de aquellas conductas colusorias descritas en los artículos 3º letra A y 62 del Decreto Ley 211 de 1973. Es importante precisar que tanto los acuerdos o prácticas concertadas para fijar salarios como para no contratar trabajadores de una empresa competidora, en la medida que sean acuerdos o prácticas anticompetitivas desnudas y que no presenten justificaciones procompetitivas, son conductas que se encuentran prohibidas por la ley, sin importar si las empresas empleadoras cuentan con poder de mercado o si generan efectos anticompetitivos. En segundo lugar, en materia de intercambios de información sensible desde un punto de vista competitivo. Las empresas empleadoras pueden intercambiar información que neutralice su independencia competitiva, así como la incertidumbre propia del proceso competitivo e infringir la ley de libre competencia. Por ejemplo, este sería el caso en que empresas empleadoras en el ámbito de una asociación gremial intercambian información acerca del monto de los salarios presentes y futuros que pagan y pagarán a sus trabajadores. Es importante precisar que este tipo de intercambio de información podría también configurar un acuerdo o práctica concertada constitutivo de colusión. Y en tercer lugar, en materia de operaciones de concentración. Las operaciones de concentración, es decir, fusiones o adquisiciones, también pueden reducir sustancialmente la competencia en los mercados laborales, perjudicando a los trabajadores en aspectos tales como la disminución de sus salarios o la desaceleración del crecimiento de estos, el deterioro de las condiciones laborales o de la calidad del lugar de trabajo. Asimismo, en materia de adquisiciones, cláusulas de no solicitación accesorias a una operación de concentración y de usual aplicación en estas, consistentes en la obligación de la parte vendedora de no contactar a trabajadores o ejecutivos que se desempeñaban en la sociedad objetivo para efectos de formularles ofertas de trabajo o de contratarlos, pueden reducir sustancialmente la competencia en los mercados laborales. En base a la jurisprudencia consolidada de esta Fiscalía en materia de control preventivo y obligatorio de operaciones de concentración, este tipo de cláusulas son legítimas en la medida en que sean justificadas en base a su ámbito geográfico, material y temporal, en virtud de que su alcance geográfico esté limitado a la zona donde la operación produce sus efectos, de acotarse a personal que sea estrictamente necesario para la operación y de no superar un plazo de vigencia de 3 o 2 años, según concurra o no la necesidad de proteger el know-how de la empresa adquirida que es transferido respectivamente. Hoy queremos reafirmar de manera muy clara que los mercados laborales forman parte de aquellos en que se aplica nuestra ley de libre competencia contemplada en el Decreto de Ley 211 de 1973. La Fiscalía Nacional Económica los vigilará con el mismo rigor con que actúa en otros mercados de nuestra economía en que se transan productos o servicios. Nuestro objetivo es promover y defender la libre competencia en los mercados laborales, detectando y sancionando conductas anticompetitivas como las que se han mencionado, contribuyendo con ello a incrementar la productividad y el crecimiento económico en nuestro país. Mercados laborales competitivos son fuente de meritocracia y movilidad social, permiten a las empresas atraer y retener talentos y, por su parte, a los trabajadores llevar sus capacidades a quien les ofrezca las mejores condiciones para desarrollarlas. Para lograrlo, ejerceremos las atribuciones que nos confiere la ley para resguardar la libre competencia, con la conciencia de que existen otras autoridades y organismos encargados del diseño e implementación de políticas públicas en el ámbito laboral, así como de hacer cumplir regulaciones laborales, especialmente aquellas que establecen derechos en favor de los trabajadores. Para un mejor entendimiento de este nuevo foco en las preocupaciones de la Fiscalía Nacional Económica, pensamos que es importante reflexionar acerca de los fundamentos económicos que explican cómo en los mercados laborales los agentes económicos pueden afectar la libre competencia por medio de distintas conductas, como es el caso de la colusión y las operaciones de concentración. Para ello, contamos con una invitada de lujo, la profesora de Economía Aplicada del Massachusetts Institute of Technology, MIT, Nancy Rose. Nancy es una economista experta en materia de libre competencia y es autora de varios papers relevantes publicados en las revistas más prestigiosas del mundo. Algunos de ellos precisamente abordan la aplicación del derecho de la libre competencia en los mercados laborales. Es importante mencionar que la profesora Rose, entre los años 2014 a 2016, desempeñó el cargo de Deputy Assistant Attorney General for Economic Analysis en la División Antitrust del Departamento de Justicia de los Estados Unidos, por lo que también tiene experiencia práctica relevante en la aplicación de las leyes de libre competencia y sus efectos en distintos mercados. Muchas gracias por su asistencia e interés. A continuación los dejo con la profesora Nancy Rose. Nancy, please.
Hola y muchas gracias. Lo siento, no hablo español, so the remainder of my talk will be in English. I appreciate your accommodation of that. I'm delighted to be invited to speak with you on a topic that I have been working on since my service in the U.S. Antitrust Division. And I applaud the very clear denunciation of labor market collusion that you just heard, and Chile's commitment to ensure that everyone in the economy, whether providers of labor or consumers of goods, benefits from vigorous enforcement of competition law. So I'd like to share with you now some of my thoughts on both the economics and perhaps a bit stretching from my role as economist to weigh in on legal issues, to give you some context of the law in the U.S. and a bit of what has been going on elsewhere. So let me, if I can now, share my screen. So hopefully that's visible to everyone. If not, someone needs to tell me that it's not. Antitrust enforcers, competition policy enforcers, are paying increased attention to buyer power, what I will refer to as upstream harm or impediments to upstream competition, and particularly so in labor markets. Anti-competitive conduct, including collusion such as employee no-poach and wage-fixing investigations, and enforcement actions in that space are gaining traction around the world. There's enhanced scrutiny of non-compete employment clauses, clauses that employees may not even realize that they have signed when they accept an employment offer that restricts them from going to work in businesses similar to the one that they're employed by should they leave their current employer, which reduces competition ex post for employment and limits employees' options. But it's not just conduct that's a problem. Mergers may also create powerful buyers. They may reduce competition and compensation for suppliers, such as workers, and they may disadvantage rivals in the buyer's markets. So there's growing concern that labor market competition has not received sufficient attention and protection from enforcers worldwide. And I'd like to share with you some thoughts about why that's so important from an economic perspective, and then also describe a bit of what the current legal environment is. This concern in part has been motivated by academic research. The early research focused on things like wage concentration regressions, which suggest a negative correlation between wages and the concentration levels, here measured by the Hirschman-Herfindahl Index, or HHI, looking across occupations, geographies, and pretty simplistic notions of what a labor market is. I think the difficulty with this type of work is that it's difficult to be certain or confident that that relationship is causal as opposed to just a correlation. So for instance, think about a relatively rural economy where one or two employers might dominate the market, and think about one of those employers leaving. Maybe it's a manufacturing firm that's been shut down due to import competition. What's going to happen in that market is that employer concentration will go up. You've lost a significant employer. And wages are typically going to go down because there's less labor demand in that market. And that's going to give you a negative relationship between wages and concentration. In addition, there's difficulty in determining what exactly bounds the labor market in this type of work. So academic researchers have pushed to see, are there better ways of identifying the impact of reduced competition in labor markets, particularly through antitrust relevant reductions in competition, so reductions in, say, the number of employers. Is there a relationship between that and earnings or wage outcomes? And there have been a few studies that have given us, I think, tremendous insight into that question. One is a study by Ellie Prager and Matt Schmidt that looks at local hospital mergers in the United States. And it looks at the impact of those mergers across three broad employee categories: unskilled workers, skilled workers, but who are not hospital-specific workers, and then at the bottom of this panel of changes in wages as a function of whether you're before or after the merger is represented by this dotted line. What's the impact on skilled workers who are have skills associated that specifically with the hospital or healthcare sector? And what they find is that the hospital mergers that most increase concentration reduce wage growth, but only for these skilled industry-specific employees. So the bottom panel, nursing and pharmacy wages, suggest that wages might decline, or wage growth might decline on the order of 5 to 10%, following a merger with the highest impact on HHI, on hospital concentration. What's important to recognize in their study is that the mergers that create the harm would be presumptively anti-competitive on product market grounds. Why did they get through? There's speculation that many of these were either consummated during a period when the Federal Trade Commission in the United States, which has the authority for enforcing against anti-competitive hospital mergers, was having a lot of difficulty successfully challenging those mergers in court, or those mergers were just too small to be notified to the agency and thus eluded their attention. There's another study by David Arnold who's looked at this question of merger impact on wages and earnings, but now not focusing on a specific industry, but looking across a broad number of industries and using information on where workers from one firm tend to go to identify whether firms are competitors in labor markets. So he measures this local labor market change in concentration by looking at whether there's a reduction in the number of employers that are close enough to attract workers from one another. And what he finds, similar to the Prager and Schmidt study, is that, again, mergers with significant changes in local labor market concentration are associated with reductions in annual earnings for those workers. This work, I think, establishes, in my mind, quite convincingly, the principle that if we reduce competition among employers, we can have a significant impact. That can have a significant impact on the livelihood and earnings and options of workers. In addition to mergers, however, there's been a lot of research that's been taking place on other forms of conduct-related reductions in competition. I'd mentioned earlier that there's concern about the rise of non-compete agreements among that employers ask workers to sign. And this is a chart that shows us the prevalence of non-compete agreements by occupation across a very wide range of occupations. What's interesting to note from here is that in some occupations, like architecture and engineering, all the way on the right-hand side of the chart, more than a third of workers have non-compete agreements in their employment contracts, making it very difficult for them, as I said, to continue in their established occupation if they leave their firm. They might have restrictions that require them to spend 6 months, a year, perhaps even more, not working for a firm that's identified as a potential competitor. And what's puzzling about this in terms of understanding this through any kind of efficiency rationale is that these kinds of non-compete agreements are hard to reconcile often with the traditional reasons that people might give for needing a non-compete, such as protecting intellectual property, sensitive employees who know key trade secrets, say, of the firm. Although I have to point out that non-compete agreements are a very crude way of protecting that property. If an employee takes trade secrets with them and works for a rival employer, the original employer can go after them for violating trade secret law, typically. Another reason that's given for non-competes is that firms might be making significant investments in employee training, and they'll be unwilling to make those investments if they train employees who then are hired away by competitors. Again, in many of these occupations, it's difficult to identify the existence of significant training. So take something like personal care, where often relatively low-skilled workers say might provide in-home health care. There's not a lot of training that goes on in most of those jobs, and it's difficult to identify that as a rationale for non-competes. You heard a bit about no-poach agreements during Jorge's initial remarks, and I think that's something that's grabbed a lot of attention worldwide. Perhaps the watershed for putting this really into the public recognition of this as a problem in the public domain was the Silicon Valley no-poach suit that the Department of Justice began investigating in 2011, and which resulted eventually in private suits against the companies that had participated in these no-poach agreements, agreeing not to hire each other's, primarily engineers, where those companies were ordered to pay $415 million to affected employees. But if that was the splashiest or the first really splashy no-poach settlement agreement, it was far from the last. We've seen agreements, we've seen no-poach agreements being prosecuted or pursued by state attorney generals in the United States, by private class action suits like fast food franchise no-poach agreements. We've seen Department of Justice settlements like the one in the railway supplier lawsuit with Wabtec and Kenora Brems, who also then had, again, private settlements given the ability of harmed individuals in the US to pursue private enforcement actions. And we've seen these issues come up in a variety of non-US settings. So in Mexico, a sanction against football clubs. In Portugal, there have been a number, including a prominent football one. The European Union antitrust regulators have announced that they're looking at no-poach deals, and the list goes on and on. So I think it's interesting to sort of step back and think a bit about how we should think about these reductions in competition among employers, in first an economic sense and then a legal sense, to answer the question, can these reductions in competition among employers create actionable antitrust and merger harms? So as I said, we'll start with the economic models, and there are two that are typically applied to understand the potential for harm here. The first is monopsony power. And I say monopsony power, which literally was a term that was used by Joan Robinson and others in the 1930s to identify a single employer or a single buyer. A single buyer. But we'll think about this also as oligopsony, that is markets with a few buyers, but again, where they recognize that they have market power. Very similar to the way we talk about monopoly power, but we don't always mean a single seller of a good. We can have monopoly power arise in situations of oligopoly. These monopsony models, I think, are best understood and applied to markets where there are posted or sometimes what we'll call uniform prices. So if we think about this in the labor market context, where an employer is posting a wage and hiring all of its workers at that wage, at least within a particular group of workers, or if this is a supplier as opposed to a labor market within a particular group of suppliers. But not all markets work that way. In some situations, wages or prices are negotiated. And so a second class of models is helpful to understand those situations. And I'll call those models of bargaining leverage, where there are negotiated prices, some perhaps bilateral market power. So this might be useful to look at in terms of a labor market where you might have a labor union negotiating with an employer or more than one employer. And we'll see that despite the fact that there might be some market power on both sides, reductions in the number of buyers who are competing for either the services of workers or the goods of suppliers can lead to anti-competitive harm if that reduction in competition is occurring because of either anti-competitive mergers or anti-competitive conduct. And if you're interested at some point in reading, a bit more detail on this, Scott Hemphill and I have a paper in the Yale Law Journal in 2018 that goes into both the economics and the law in much more detail. So let me start with monopsony. As I said, monopsony models, I think, are probably best applied to markets where we have posted prices. So we think of monopsonists as facing an upward sloping supply curve for the good that they want to purchase. So here I call it the input supply curve. You could think of it as a labor supply curve in a market. And those buyers, recognizing that they face this upward sloping supply curve, also recognize that if they restrict their input use below the competitive level would be where the input supply curve crosses the input demand curve. If they instead restrict their purchases, say of labor, they can lower the wage that they're paying to all of their workers. In this diagram, it would move from the competitive wage to the monopsony wage. And that sort of markdown of the wage, that pressure down on the wage to the monopsony wage level, reduces the wages that are paid by employers to workers, but also create a wedge between the marginal value of the worker's product that's given by the input demand curve and the price that they're paid. And that wedge is marked in this graph by this red angle. So that wage markdown is reflecting the harm that's created by exercise of this monopsony power. In this framework, the price paid for inputs, as well as the quantity of inputs, fall. The markdown widens. there's very likely downstream harm because if you're hiring fewer workers, you're producing fewer inputs, or I'm sorry, producing fewer outputs. And so your quantity of goods that are being sold and that have been produced by those workers is typically going to go down. But what's really important, and I think confuses a lot of people who think about the impact, say, of a merger that might increase monopsony power and therefore result in lower wages, is that despite the lower wages, there are no efficiencies or cost reductions to pass on downstream. That's very important. So let me pause and just emphasize that. Why is that the case? Even though, as I've showed you here, the monopsonist is paying lower wages, it's because the monopsonist sees a higher cost, a higher marginal cost to each employee than the wage that it pays. And that's reflected by that gap. So the monopsonist sees the marginal cost of labor on that higher curve that I've called the marginal cost of input or marginal expenditure curve. And so the monopsonist doesn't see that the marginal cost has gone down as a result of having more monopsony power. If anything, it sees that the marginal cost has gone up. So there isn't a lower marginal cost that's going to lead that monopsonist to produce more output. This is very similar for those of you who are more comfortable with a monopoly market, where we understand that in a monopoly, the monopolist does not see the demand curve as its marginal revenue curve. Instead, the monopolist recognizes that marginal revenue lies everywhere below the demand curve, and so restricts its output, its decision to produce output to equate the marginal revenue with the marginal cost of production. Here, you're getting a similar restriction, but it's on the input use. So really, I think this is really important because we should not pause to think about the importance of enforcing against reductions in competition through, as I said before, either conduct or merger, thinking that we might be blocking some type of benefit downstream, because in a monopsony case, there's no benefit to be passed on downstream. All right, the second model is this bargaining leverage model that I mentioned, as I think applying more to contexts where prices are negotiated. So I'm going to give you an example here, not directly in the labor market space, but I'll give you an example of a hospital that's facing a merger of health insurers. And let's suppose that the value to the hospital of being in an additional private insurance network, so this is very US-centric, where the dominant form of health insurance for anybody under 65 is private insurance, and insurers negotiate with hospitals for what their rates or what their discounts from rates will be, and decide whether or not to include a particular hospital in the network of coverage that the health insurer provides. So in this example, we're going to think about perhaps say 4 health insurers that are each of size L. That's the first top horizontal arrow line that I'm giving you. And in that case, the incremental value to a hospital of having that last insurer of size L in it, of being a network for that last insurer of size L, is the height of that blue curve, its value curve, between L and in this case 2000 minus L, and that's the height given by M. So if we had 4 insurers and the hospital's negotiating with this last insurer of size L, the hospital and the insurer would be negotiating over where to split that surplus M. What happens, however, if that insurer merges with another insurer and now becomes a 2L size insurer? Well, in this case, the hospital and the insurance network are negotiating not over the division of surplus M, but over the division of surplus M plus N, that much higher than 2M gap, that larger red arrow. Essentially, what goes on here is that because the new merged health insurer can deny the hospital access to half of the insured lives. The threat of not reaching a deal with that hospital leaves the hospital worse off. It has fewer competitive alternatives, and the new merged health insurance can exercise additional market power against it and reduce the payments to the hospital. Whether this reduces quantities or not depends on whether bargaining is what economists call efficient. That is to say, the hospital and insurer negotiate not only over the rate or the price, but also over the number of patients who will be treated. That typically isn't really done. The negotiations are over price. But even if we had short-run impacts that didn't affect the quantity of health insurance, or I'm sorry, of health services that were being provided, we would, I think, expect that the long-run quantity effects would manifest through reduced investment or exit, as the hospitals in this example had lower returns on investment and reduced payments by health insurers. Okay, so that's sort of the two economic models that I tend to apply to thinking about upstream harm and in particular labor market harm. What are the legal standards for enforcement? So as I say here, I think historically, antitrust and competition enforcement pretty much worldwide has focused most of its attention on downstream harm, that is, harm to purchasers of goods and services. However, that's not because, in most cases, again, the statutes require that. In fact, most statutes reference competition, not competition downstream or competition upstream. They just talk about protecting competition. The consumer welfare standard, which is a convenient shorthand that's been used in many jurisdictions as describing the kind of touchstone for antitrust enforcement, is just that. It's a convenience shorthand, but it's not applied literally in most jurisdictions. So for example, mergers by firms who do not sell to final consumers are still blocked often, challenged and blocked often by competition authorities. Whether, that and without the need to trace the effect of that merger all the way through levels of some supply chain down to the final customer. Moreover, mergers of firms where if there's a price increase, it doesn't affect anybody's marginal cost because it's a fixed cost component, again, are also challenged if there's a reduction in competition, despite the fact that if we really thought this was a final consumer welfare standard and there was no impact on marginal costs, there'd be no impact potentially on final prices. So I think it's much more reasonable if we're trying to think about how this enforcement interacts with labor markets, to think of this as a trading partner welfare standard. And that seems to me to be much more what courts look to, with a symmetry between monopoly and monopsony. As I said, this is discussed much more in my paper with Scott. But let me give you a couple of examples from US case law to really hit this point home. So there are two significant Supreme Court decisions that I think validate this approach that I'm arguing competition authorities have taken and should take. The first is Mandeville Island Farms, which was a 1948 decision involving a buyer cartel among sugar beet refiners. So that buyer cartel was attempting to lower the price that the refiners were paying to farmers of sugar beets. And the court held in that case that the Sherman Act, the relevant US antitrust act against this type of conduct, does not confine its protection to consumers or to purchasers or to competitors or to sellers. Again, emphasizing this importance that the Sherman Act was involved with identifying illegal restrictions on trade, illegal cartels or collusion, and not concerned with those in just a narrow segment of the economy. The second case is a much more recent case, and that's a case involving Weyerhaeuser, who was a timber processor, and the allegation of its predatory behavior in the timber input market. And the court in this case held that the kinship between monopoly and monopsony suggests that legal standards should apply. Again, the court saying, it doesn't matter if it's downstream or upstream, we can analyze these in the same in the same framework. And then finally, to go to a very recent case, NCAA versus Alston, this is a case that involved the National Collegiate Athletic Association and its caps on educated-related compensation to student athletes. And in this decision, the court held that the NCAA exercises monopsony power and concluded that its caps on education-related student-athlete compensation violate the Sherman Act. So the Supreme Court, when it's been asked to weigh in on these questions, I think, again, makes very clear the symmetry between anti-competitive actions, whether they're downstream or upstream, and the rule of law to protect both suppliers, which we can read as firms that supply goods and services or workers that supply their services, and purchasers. In terms of bargaining leverage, the Supreme Court has not weighed in on this yet. But there are a variety of court decisions in the US that read primarily on downstream markets and bargaining leverage, and that's in part just because those are the cases that have come before them. So they're all either federal district court or appellate court decisions. And what they've established is that no output restriction is needed to find anti-competitive effects from increased bargaining leverage. So the maybe canonical case in this vein is the Federal Trade Commission's case versus ProMedica, which found that increased bargaining leverage by hospitals versus insurers is actionable without the need to show any output reduction. And furthermore, concluded that the courts have concluded that overcharge damages can be based on this transfer of surplus from one side to the other without having to show output effects or deadweight loss. Okay, so let me broaden now. Those are kind of the case laws on this general principle. Let me broaden now to talk about the specific aspects of labor market anti-competitive action. And I'm going to start with the US and then just briefly mention a few elsewhere. So if we start with the US and look at labor market collusion, I'd mentioned earlier the Silicon Valley no-poach case. That involved a Department of Justice settlement with the parties involved in this with an injunction. So it was a civil DOJ case. So an injunction of prohibition against continuing those types of agreements. And then, as I mentioned, private cases that settled with very considerable damages awarded to employees. The DOJ, that's not their only civil no-poach case. They've had a number of no-poach cases, including relatively recently, salary caps in esports leagues and information sharing agreements among poultry processors that affected their labor market outcomes. There have been states that have been quite involved in prosecution of no-poach agreements. New York and Washington State are two of the most active, but a number of state attorney generals have been involved in this. There have been private enforcement cases against sports leagues, against franchise no-poach, particularly in the fast food sector, against information sharing and others. And then, as I mentioned, there's the Supreme Court decision that has applied the Sherman Act to college athletic compensation caps and ruled those to be illegal. And that action, that decision in 2021 and kind of subsequent action in this space seems to be creating a quite dramatic change in the relationship between student athletes and the universities that employ them, essentially. A more controversial aspect of enforcement has been to move the no-poach and wage fixing agreements from civil enforcement to criminal enforcement. And this was a decision or a clarification of the antitrust and FTC interpretation of the law that I was very proud to have been part of in the issuance of 2016 guidance for HR professionals. And that guidance outlined a range of labor market labor market practices that were viewed as anti-competitive, and importantly, announced the intent of the FTC and the DOJ to investigate and then prosecute criminally where appropriate labor market collusion conduct. The DOJ had its first guilty plea in a labor market collusion case in US versus VDA. That's a case that involved contract nursing services. And they've continued to press on this agenda. I will acknowledge that jury convictions of individuals for no poach or wage fixing have so far eluded DOJ prosecutors. So it's been, I think the division has found it difficult in a small number of cases that they brought, but nonetheless, I found it difficult to convince juries to convict and send individuals to jail for these types of, particularly these no poach agreements not to hire from one another. The antitrust division withdrew from a couple of cases that were scheduled to go forward. I think it seems to have called a temporary pause. I expect it to be quite a temporary pause. I would anticipate that these prosecutions will resume, perhaps with some greater attention to case selection, so that they can bring only the strongest cases with the best set of facts, and begin to establish the conviction record that will then carry forward into further cases. I don't think this is that unusual when the DOJ in general or the antitrust division in particular are kind of pushing forward law, advancing law in a way that that individuals are not accustomed to, but I think it does remain a challenge for them. What about beyond the US? I've spent a lot of time talking about the US. And what about labor market antitrust beyond collusion? So I'll start with US more than collusion and just mention a few other areas of law where it's become, where the agencies have become much more active. In terms of conduct, the Federal Trade Commission right now has a proposed rule to ban most non-compete agreements. If I had to guess as to what headwinds that final rule will face, I expect them to be considerable. The current Supreme Court seems to be very skeptical of regulatory agencies, particularly when they're moving into new areas. But I think the FTC's work on this rule and its analysis of comments that have been received in response to it are likely to give the agencies a lot more information on how to think about non-competes. And even if an economy-wide rule does not go into effect, perhaps to give them some better insights into how they might use competition law to go after some of the most egregious non-compete agreements. A second category of conduct that's received attention are buyer cooperatives. These have a rule of reason applied to them, but I would say the agencies seem to have increased skepticism. I give as an example of that the Department of Justice withdrawal of its healthcare guidance after deciding that perhaps the kind of safe harbors that now quite dated guidance established were too generous, and they're more concerned about the impact of those buyer cooperatives. And then finally, I think we're seeing increased attention to information exchanges and a tightening of how the agencies will look at information exchanges and the rules that they'll apply. The second big category of non-collusion cases are merger cases. So there have been a number of settled merger cases that alleged upstream harm in markets that range from meat processing to health insurance to yogurt and beyond. Some of these specifically reference labor, like healthcare providers. Some of them are just, and farmers, and some of them are just thinking about upstream harm generally. But I think those were important to establish the agency's concern with the potential for mergers to harm sellers. There have also been a variety of no-poach agreements that were uncovered in merger investigations and referred for conduct enforcement. I will say that, and this is the same, this happens occasionally in price fixing as well. I have to say it amazed me when I came to the Department of Justice to realize that it was not all that uncommon to find in our investigation of mergers evidence that the firms had been colluding either in prices or in labor market agreements not to hire from one another, and that the firms nonetheless proposed the merger, recognizing that they were going to have scrutiny of their interactions with competitors. If you represent clients that are thinking about mergers, I would urge you to have them think hard about this. As I said, it's great for the behavior to have been uncovered, but it kind of stuns me that firms don't do this kind of research for themselves and then self-report under leniency. The labor markets as an area of study in merger investigations have now been incorporated into the FTC and the DOJ standards for investigation. They're something that are looked at in their initial screens, and then if those screens suggest problems in their further investigation. And there's a proposal to have a lot more labor market information in the Hart-Scott-Rodino filings that are required for mergers above roughly $100 million. And then finally, in the 2023 merger guidelines that were just released by the agencies yesterday, there's expanded language talking about the role of labor markets and how they intend to incorporate those into their investigations. Outside the US, we've seen a number of enforcement agencies issue guidance similar to what the US issued in 2016. Two quick examples are the Japan FTC issuing guidance in 2018 and the UK Competition and Market Authority announcing its interest in this in 2023, and Vestagier's 2021 speech on cartel enforcement in the European Union, all kind of providing some guidance and highlighting the interest of agencies in understanding labor market impacts. As I said before, we've also seen competition enforcement in wage fixing and no poach cases. In Canada, the law has been amended to criminalize labor market collusion and make it possible for the authorities to go after that criminally. In Mexico, we've seen no poach agreements in football that have been investigated and pursued through a fine. Investigations that were opened in Brazil, say in a healthcare wage setting context, in Colombia, again in football. Peru had a construction no poach. And there have been national authorities in Europe, in Portugal, Spain, Poland, Turkey, France, a lot of others, as well as the CMA and the UK that are moving into enforcement actions in this space. And then finally, we have the announcement and discussion that you heard today, announcing or clarifying the intent of Chile to make this a priority as well. Let me say a couple of things about mergers, because I think that's been an area that hasn't had as much attention internationally as well as in the US. And why do I think it's important to call these out? Because mergers are so important in preventing problems from arising in the first place. So if we've got independent competitors and they're competing vibrantly with one another, we'd like to make sure that we maintain that and we don't create a monopsony problem or a greater monopsony problem by eliminating, say, an employer, or we don't create the potential for greater collusion because we've reduced the number of firms that need to look across their shoulders at one another and collude either explicitly or tacitly. Despite that, and I mentioned there were some settled merger challenges that involved upstream harm, the Anthem Cigna Health Insurance merger in the US, which was decided in 2017, challenged in 2016 while I was at DOJ and the final decision coming out in 2017, was, to my knowledge, the first litigated US merger to add an upstream harm allegation to downstream harm allegations as well. Despite that, and I was thrilled to see that allegation added to the complaint, the litigation really did not focus much on the upstream market harm. The primary upstream dispute was whether the companies that acknowledged they were going to reduce the price that they paid to providers upstream should get to count those as cognizable efficiencies, or whether those cost reductions would occur at all, and if they did, were they actually evidence of further merger harm? So despite my disappointment that we didn't have a robust discussion of upstream harm as a reason to challenge the merger, there was a lovely appellate decision that came out of the DC Circuit Court of Appeals, which held first that to have any legal relevance, a proffered efficiency cannot arise from anti-competitive effects, and that securing a product at lower cost due to increased bargaining power, go back to that leverage story I talked about, is not a competitive efficiency when doing so simply transfers income from the supplier to the purchaser without any resource savings, citing Arita and Hovenkamp in that. So I think that was very important to again emphasize that even in a leverage context, you couldn't say just because you were reducing payments upstream, that was an efficiency. In fact, it could be another anti-competitive harm of the transaction. So we go to 2022, which is the first litigated US merger where the merger is challenged entirely on the basis of upstream harm to authors. This is the Bertelsmann Penguin Random House proposed acquisition of Simon & Schuster, where the DOJ alleged substantial harm to authors of anticipated top-selling books. They said the merger would depress author pay and reduce the quantity and variety of titles by eliminating head-to-head competition between these two publishers and would facilitate coordination among the remaining Big Five publishers. And the judge in this case held for the US on both unilateral and coordinated effects harms to authors. And what's really quite lovely about this opinion is that she doesn't even really seem to have any concern about the novelty of a labor market case. She just reads this body of evidence and testimony as evidence that the merger reduces competition, acknowledges that the law says that mergers where the effect may substantially be to reduce competition are illegal, and declares the merger illegal. So I think this is a terrific case that will help to clarify both for parties that are considering mergers and for agencies and future judges, where the labor market and upstream harm law falls. So if we're going to do that in mergers, what do we need to do to move forward? I think what's very important in this context is how to identify mergers with labor market harm without substantially increasing enforcement and litigation costs, both of which are already quite substantial in the US, and enforcement costs, investigation costs are pretty high, regardless of whether you have to go to court to block a merger or not. And so the types of questions that we're grappling with in this space are, how do we decide what the bounds of affected labor markets are? Is a merger likely to significantly change competition in those markets? Can we use our HHI thresholds from product markets? Do we need to tailor new ones to labor markets? Are there analogies to the upward pricing pressure types of screens that we use in product markets? And then I think finally, but maybe really something that we need to think about first if we're investigating these or considering an investigation, is whether labor market harm is likely to align with product market harm. So we go back to that hospital merger study that I described for you. I said the study shows that reductions in competition through hospital mergers can have dramatic effects on labor markets and workers, as well as effects on product markets. And in that case, we may not really need to look that much at labor markets. If we know how to challenge anti-competitive product market mergers in that space or that industry, we can just apply that screen, knowing that by protecting the competition between the hospitals and protecting the buyers of their services, we're also protecting the workers that they employ. But where that type of approach might fall short is, say, a merger between a hospital and a skilled nursing facility, a long-term care facility, where the two may not really compete in product markets, but where they may be hiring from the same labor pool. They may both be drawing heavily on, say, skilled nurses. And so the reduction in competition between the hospital and the nursing home might reduce competition for nurses, lowering their wages, even though there aren't product market effects. Or we might take an example of an industry where there are substantial where there's a local labor market, like a paper mill, which might be, if we have two paper mills in a region, they might be significant employers of the same type of workers, but where there might be a national product market, paper gets shipped over very long distances. And so the merger might not have a big effect on the product market, given that it's a national product market, but could have a very big effect on a regional labor market. I think this is also important when we think about merger remedies, to understand that say divestiture that might fix a product market overlap, say in a national market where we're divesting maybe arbitrarily some plants, where it might be important to design that divestiture remedy to ensure that we're maintaining labor market competition if that's important. So I'd like to suggest that when we're thinking about mergers, we ask those questions first, and then drill down on labor markets only where we think that there's a divergence between product markets and labor markets, or where we think the labor market harm is going to be easier to investigate and demonstrate. So, thinking about objections that I've heard to actions against anti-competitive employer conduct, first, does a consumer welfare standard mean that suppliers are not protected from anti-competitive conduct? I would argue the answer is no. Is harm actionable only if it manifests in downstream, that is to say, output markets, as well as these upstream markets? I think the law and the economics are both clear. No. Should enforcers balance downstream benefits against upstream harm, or require plaintiffs to show that there's no pass-through of harm? I'm sorry, no pass-through of these lower upstream costs, as I've suggested. I think the answer on both economic terms and the law is no, unless you're in a regime where the law requires cross-market balancing, because I really think these are separate markets. And if your law, like the US, says a merger is illegal if the effect may be substantially to reduce competition in any relevant market, then once we've got labor market harm, we don't really need to worry about whether there are downstream harms or benefits. Finally, are upstream price reductions merger efficiencies? No, if the realized price reduction is from a reduction in competition between the merging firms, as opposed to some real resource savings. This is the type of analysis we do in merger efficiencies all the time, but I think it's really important to emphasize that we need to be sure that if there is an upstream price reduction, it's not arising from any reduction in competition. And then finally, and this was a big argument in the Anthem Cigna insurance case, isn't countervailing power by buyers a good thing if the sellers have market power? And here I would say that the answer that I think is a policy decision that we need to come to, and I think it's consistent with the way US law has approached this, is to say, that's an economically very complex question. It essentially requires us to look at the general equilibrium effects throughout the economy of some particular merger or action. And that type of question is not well suited to be answered either by enforcement agencies or courts. We really, I don't think, can ask either of those entities to determine the optimal configuration of the economy, as opposed to asking them just to protect competition in the defined markets that we've identified. I think it's very hard to resist the temptation to act as a market designer and say we could figure out something better. But fortunately, I think US law at least is quite clear on this. So in Philadelphia National Bank, the Supreme Court said that a merger that may substantially lessen competition is not saved because on some ultimate reckoning of social or economic debits and credits, it may be deemed beneficial. And in the district court decision in Anthem and Cigna, the judge, I thought, had a very clear way of thinking about this and said courts should not be in the business of making policy determinations about the appropriate allocation, in this case of healthcare dollars. Those are value judgments that are better directed to the legislature. So I hope that enforcement agencies around the world will be able to resist the temptation to think that they can take in a body of effects across the entire economy and decide whether, some harm to some workers is beneficial because once you trace it all the way through the market, there's some offsetting consumer benefit in some other market. I think it's much more effective and reasonable to expect our competition enforcers to decide on what the effect is on competition and not on overall design of the market economy. So my forecast, I think there are very strong economic and legal arguments that competition law protects competition, upstream, downstream, across, however. But the headwinds that exist against enforcement for many enforcers in downstream markets are at least as strong for upstream and labor markets. And that's a challenge that we're going to have to rise to. I think that the enforcement agencies are capable of rising to that. And I'm confident that we will bring in areas where the courts are reviewing their challenges, that will bring the courts along. There's a lot to be done to ensure that competition benefits workers and suppliers, not just purchasers. And I think that today's announcement and discussion of this topic is an important step forward. So thank you very much for inviting me to join you today. It's been my pleasure to share these thoughts with you.
Thank you, Nancy, for such an interesting talk. Muchas gracias, Nancy, por su interesante presentación. Con esto damos por finalizado el seminario del Día de la Competencia y en nombre de la FNE agradecemos a todos por su tiempo e interés y esperamos contar con su asistencia en el próximo seminario que realicemos. Nancy, Jorge, would you like to stay a moment so we can take a screenshot?
Certainly.
I think they have it already. So thank you very much.
Thank you.
Thank you very much, Nancy. It was a very interesting, clear, excellent presentation. I think it covered all what is needed for making this a focus on the FNE's actions.
Well, I'm looking forward to hearing about those actions in the future.
Sure, we will keep you posted.
Thank you.
Rose?
I think so, gracias a todos.